it's okay, I would argue that the argument acceptable.
Which one are you first?
Premises liability one.
Okay, that's,
Should have been the wrong one.
okay. Judge Warner. Okay, go ahead.
Okay. Here, Your Honor, the main point is, with regard to plaintiff's claim that she tripped on the road, there's no actual construction knowledge. As you know, in Indiana, Indiana does not make landowners absolutely liable for defaults on their property. All they have to do is exercise reasonable care to protect somebody's from foreseeable dangers. So that means they're not, a landowner is not an insurer of invitees' safety. So before liability can be imposed, there needs to be actual and constructive knowledge. And this is a requirement. And plaintiff has introduced no evidence that St. Mary's first had actual knowledge of the bump in the road, or the flip-flop corner of the road. I'm sorry. And the only employee that actually didn't testify was Amber. She said that she didn't know it was flipped up. She wasn't even in the building at that time. And the plaintiff didn't testify herself that any of the employees had actual knowledge of the flip corner at that time. And then with regard to constructive knowledge, it needs to be such a length of time that the employees of St. Mary's would have noticed the defect. And here again, she testified that the appointment was at 2 p.m. The ambulance was called, and evidence that the dispatch was notified at 2 p.m. So, she wasn't she wasn't in the building for a matter of minutes, I think she testified. So, and in addition, there's evidence, actually did this chart in the motion that she was walking at a pace of around 0.7 miles per hour on the treadmill prior to the fall. And we have in evidence 144 feet. If you do that, it would take around 2 minutes and 20 seconds to walk around. That means when she walked in, there was no defect. 2 minutes and 20 seconds later, defect. There's no way that St. Mary's could be held if they had constructive knowledge of that defect. And without actual or constructive knowledge, the plaintiff has failed to show completely that none of evidence is proper.
They put the rug there, Judge. It was their rug, and they had knowledge of the rug. So I don't know what else I can say. We also went through the rug, which is right here. And I lifted it up to the witness, and you can see there's a defect here, here, there, here. It's their rug, it's on their floor. Their receptionist is but a few feet away. My client testified that Maria Doctor was in the gym, in the room at the time she fell. There was more than enough evidence to premises case.
All right.
If I could just say one thing. If those defects that he just pointed out are not the defects that she said that she fell on, she was flipped up corner. And to be clear also, just because the rug is there, which is what he's trying to say, that is not proximate cause of her fall. The proximate cause is the flipped up corner. Because that's an intervening cause of whatever he wants to say, the placement of the rug was, that's what caused her to fall. That's like us saying, her using a cane is what caused her to fall. Her having her condition, that's what caused her to fall. That's what's being the rug and saying the rug in there is what caused her to fall. No, what she testified to is what made her fall was the flipped up corner. So, sorry, I didn't point. Sorry. But because she testified to that, as a matter of law, that's the proximate cause with regard to her allegations. And she can't.
The point of the whole case, Your Honor, is that she fell on the rug. The rug should not have been there in the first place.
That's a
Please. The rug should not have been there. There was no reason for it to be there. It was a arrived they had rugs when they entered the facility. This thing served absolutely no purpose.
The motion's denied.
Thank you.
Okay.
And then, quickly, with regard to the Med-Mal claim, this court knows that in order to sustain a Med-Mal claim, plaintiff needs to set forth an expert opinion. And on both breach of the standard of care and proximate causation, and the plaintiff did not do that in this case. The only evidence that was presented was Sashi's testimony, which I read in, and he never said it was a breach. All he said was it wasn't a good idea, or I think it might have been better in a different place. That does not amount to a Indiana case law says that you need clear language that something was a breach. And he didn't say that at all. And that was the only position that he didn't testify to that fact, which that mattered. Language merely states there are better options but not amount to standard of care. In addition, not only did he not sufficiently do standard of care, there was also no testimony at all with regard to proximate causation. There's evidence that because the plaintiff was, her leg was weak, that gave out and caused the fall. That is not something that, that's something that cannot be observed by the layperson jury. It needs a medical expert to testify, oh no, that couldn't have happened. He doesn't have that, she doesn't have it. They didn't present any evidence to rule that out. And without evidence to rule out proximate causation, they haven't satisfied their burden. So on that claim, the Med-Mal should also be withdrawn from the jury.
Your Honor, we can put an end to this. If you look at the instruction or the exhibit book tab number 18, the first page says the undersigned chairman for the above captioned medical review panel attaches Exhibit A, Exhibit B, and Exhibit C.
Which ones are 18?
18. Which reflect the opinions of each of the three panel members. First opinion. The undersigned panel member hereby renders the following opinion. There is a material issue of fact not requiring expert opinion bearing on liability for consideration by the court or the jury. The medical review panel in this case, Your Honor, determined that this was a factual issue that had to be resolved by a jury. So I don't know what more we can do other than be here and let the jury decide.
That doesn't go to whether there was a breach, whether liability should be. That is the medical review panel process.
So your argument is jury can't decide what she fell on?
Well, no, it's not what she fell on. It's what...
Or how she fell?
How she fell, because...
Well, that's the issue for the jury to decide, isn't it?
It is an issue for the jury, but they need to present expert opinion, which they did not, of, ruling out that it was because of any mistakes, because she tripped on the rug.
That's what three panels decided. There's no effect.
That's what she stated.
That's what who stated. That's what she stated. Expert opinion is what I'm saying. Those are Med-Mal claims. They all need expert opinion before they can go forward at all. And just because she said it happened, that's not an expert opinion. An expert, a medical expert, like the one that we.
So your argument is that a medical expert should have been there to watch her fall?
No, a medical expert can go through the medical records, evaluate, she had these kind of, issues, these kind of medical conditions beforehand, and could either rule out and say, this is why she fell. Well, that's what I said. An expert opinion with regard to the breach of standard of care also, but she did not do that either.
Well, Sashi Bombat testified that she should have had somebody with a 24/7. But all people said that. So the standard of care was established. Sashi also said the rug shouldn't have been there. And I don't know how much clearer you could get by what the panel said. They didn't decide this case because they said there were issues of fact that the jury had to decide.
Your Honor, may I say something?
Yes.
I think the court makes that decision.
Well, I'm going to make the decision and deny the motion. Okay. Give me 5 minutes so I'll bring the jury back in, all right?